My name is William Kovatch, and I am an immigration attorney. This presentation is meant to give you basic information on a deferred action program for people who arrived in the United States before age 16. The President and the Secretary for Homeland Security announced the program on June 15, 2012. Its requirements are based on the DREAM Act, a bill which did not pass Congress approximately 2 years ago. As such, this is an exercise of the President's discretion and not law, but those who qualify may also receive work authorization. In order to qualify for deferred action under this program, you must have been brought to the United States before your 16th birthday. You must be 31 or under by June 15, 2012. You must have been physically present in the United States before June 15, 2012 for 5 years. You must currently be physically present in the United States, and you must show that you were physically present in the United States on June 15, 2012. You must be enrolled in a U.S. school, have graduated from a U.S. high school, or have a GED. You may also qualify if you are honorably discharged from the Coast Guard or from the United States Armed Forces. You must have no felonies or any serious misdemeanors, and you must have less than 3 other misdemeanors. In addition, you must not be a threat to U.S. security. In order to apply, you must complete 3 forms. The first is Form I-821D, where you will be asked basic information about yourself and about your presence in the United States. You must also complete an application for work authorization on Form I-765 and a worksheet, Form I-765WS. The worksheet is used to determine if you qualify for work authorization. Finally, you will be required to submit certain other documentation. The required documentation includes proof of your identity. This can be a passport, a photo ID, or a birth certificate. You must show proof that you came into the United States before your 16th birthday. This can include mail to you, school records, or anything else you have that shows that you came into the United States before you turned 16. In some instances, you must show proof of your immigration status. If you entered on a visa which expired, you should show a copy of your I-94 card. You must also show proof of your physical presence in the United States. You must show that you were in the United States for 5 years leading up to June 15, 2012. You must show that you were present in the United States on June 15, 2012, and that you were physically present in the United States when you made the application. Proof can include mail, it can include school records, or anything else that shows that you were present in the United States. You will need to show proof of schooling, school records, your GED, or even your diploma. If you are applying because of your military experience, then you must show proof that you were honorably discharged. And finally, if you do have any arrest or convictions, you must provide a copy of your arrest and conviction records. You must share certain information when you complete your immigration forms. You will be asked your identification and your current address. This includes your date of birth, your alien identification number if you have one, and your social security number if you have one. You will be asked if you are in removal or deportation proceedings. You must disclose where those proceedings are and when the next hearing will be. You must disclose how you came into the United States. This includes where you came into the United States, whether you came in on a legal status, and when that status expired. You will be asked whether you used any other names, any aliases. You will be asked school information, where you went to school, the address of the school. You will be asked military information if you are applying based on your military record. You must disclose all addresses where you lived in the United States. You will be asked whether you were arrested or convicted, and you will be asked certain questions on whether you pose a security risk to the United States. You will also be asked what your income is, what your expenses are, and what is the value of your assets. If deferred action is granted, you will receive a promise from the United States government that it will not try to remove you or deport you from the United States. It is possible that you could also receive work authorization. If you receive work authorization, you will be able to obtain a Social Security number so that you can legally pay taxes in the United States. The Department of Homeland Security has promised in its guidelines that it will not use the information disclosed in the deferred action applications in order to remove the alien unless there is a criminal history. There will, however, be a background check performed so that even if you do not disclose a criminal history in your forms, if you were arrested or convicted, the FBI will know about it. You should note, however, that this is an act of discretion. It is not an act of law. That means that the guidelines are not legally binding on the United States. They are simply promises of the government of what it will and will not do with the information. There is always the risk that if the administration were to change, that the new administration will not honor the promises. Indeed, there is no guarantee that the current administration will honor its promises past November. You must also know that deferred action will only be granted for 2 years at a time. That means that you will initially receive a grant for 2 years, and you must reapply in another 2 years. Once you receive your deferred action, you of course can travel within the United States. As far as traveling abroad, you cannot travel abroad before deferred action is granted. After deferred action is granted, in order to travel outside of the United States, you must first apply for advanced parole. Knowing that there are some risks if you do apply for deferred action, the question is whether you should. If you are already in removal or deportation proceedings, then the worst thing that can happen has already happened. You might as well apply for deferred action if you believe that you qualify. If you have already been ordered removed, or if you have already agreed to voluntary departure, then again, the worst thing that can happen to you has already happened. You might as well apply. In addition, after considering all the risks involved in making an application, if you believe that it is important to you to receive a chance to get work authorization and work legally in the United States, then you should apply. If you apply for deferred action, you must pay a government filing fee of $465. If you were to hire me to assist you in your application, I would charge you $500 to fill out the form, collect the documents that you need, enter my appearance on your behalf, and engage in a reasonable follow-up with the agency. If an interview is required, I would charge you $500 to attend the interview with you. At this point, deferred actions are being granted without the need for an interview. However, I cannot guarantee that that will continue in the future. In addition, if the government sends you a notice of intent to deny, or sends you a request for evidence, or if you are denied and you wish to file a motion for reconsideration, then my fee would be based on an hourly rate of $250 an hour. Thank you for your attention to this presentation. If you have any further question on deferred action, or if you wish to make an appointment, please call my office at 703-837-8832. Again, that number is 703-837-8832.